All right, good morning, everyone. I'm Judge Jackie Powell, and we are here in first appearance court. Today, I will let you know if I've determined probable cause, and then we will talk about release conditions. I want to encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If there's something that you wish to say to the court, you may want to consult with your attorney before speaking on the record. For those of you who are represented by the Public Defender's Office, I do have one attorney sitting in the courtroom with me, Mr. Brian Reedy, and I also have, there's also an attorney over at the main jail from the Public Defender's Office. You may be able to speak with those attorneys. If you are represented by private counsel, your attorney normally comes to the courtroom and addresses the court. If your attorney is not here, you can let me know if you have private counsel. But please don't send us to make phone calls if you have not retained that person for this arrest. Just because an attorney represented you 2 months ago or a year ago or your family members, it doesn't necessarily mean that they're representing you here unless you have retained counsel for this arrest, okay? And so also note that I do have the state attorney in the courtroom, Mr. Eric Linder, and I also have pretrial supervision services as well as confinement status. They can provide additional information if needed, and also I have the clerk of court who maintains the records, okay? So I will address each person individually, and if, when I call your name, if you will come up to the podium, and we will address that case. All right, I've been asked, there's a motion to revoke bond that has been filed.
Yeah, well, I'll just wait till he gets up there.
Okay, go ahead.
No, I just, was gonna wait till he's up there, Mr.
All right, and so at this time, Lehman Mathis, who is on page 20. Good morning, ma'am. All right. Now, I know you've been here before, and I know what the situation is before, but today, the state has filed a motion to revoke Mr. Mathis's bond. They filed a motion, and so I have to give them 3 hours. So this is going to be reset for the afternoon.
Your Honor, if I could address the court.
Okay.
And I know I filed a motion, and it was in an abundance of caution.
Okay.
Your Honor, I believe has had an opportunity to read the new probable cause affidavit. I believe Your Honor is familiar, and I provided a copy of the previous, probable cause affidavit. I filed my motion in case the court was not intent on, assuming you find probable cause for the new offense, not revoking his bond sua sponte.
Okay. So you filed a motion, so I have to give you 3 hours.
Okay, well, okay, that's fine. All right, we'll
Okay.
set it for one.
I'm sorry? Yes. know you're here, so is there something you wanted to say? All right. So the situation is that Mr. Mathis was before the court before. And we did go through attempting the mental health evaluation. And then the court finally released him to your custody. I remember you and your mom came before the court and said that you'll be able to give him what he needed to keep him, right? But now he's before the court this morning for violating a risk protection order. And he was attempting to purchase a firearm. And so the court does have cause for concern for the community. And I am going to sua sponte to revoke his bond at this time. He's going to be held no bond because there is not only cause for concern for the community, but also for Mr. Mathis. And so if you will work with his attorneys moving forward on what can be done, that's what we'll have to do today.
First of all, you don't understand. I tried to explain that to them. I explained it over and over. They're giving paperwork for him to sign, and he's not aware of it. I told them that. I explained that in the civil courtroom as well.
Right. Well, if you
He's not going to do anything to anybody, nor himself. He's not that kind of a child.
Ma'am, I understand, but I have to work with what is before me. And you were here before and said that you would be able to control him, and now he's out purchasing weapons. So there has to be another route at this time.
Okay, so what are you imposing as another route? Because keeping him incarcerated is not going to get it.
Okay, ma'am, I
So
understand. I understand that you're upset. So I'm gonna ask you to step away from the podium at this time. I have made a ruling. He's going to be held no bond until further order of the court. Okay?
It's bullshit.
All right, ma'am, I'm gonna ask you to come back to the podium. Come back to the podium. Come back to the podium. And you need to tell me this morning why I should not hold you in contempt for what you just said to the court.
To who, you?
Yes, ma'am.
No, I didn't say that I'm talking. I wasn't talking to you, no offense.
Okay.
I've been up all night.
Okay.
I've been up for the past couple of days. Even with this, I try to do everything that I can. I'm not understanding why he don't understand, why he's not processing this.
Right. Okay, so then I'm gonna ask you to take a deep breath. If you need some water, you can have some water, but I will not tolerate disrespect to the court, okay?
So when will there be a next birthday?
All right, you need to speak with his attorneys to make your determination, make what the next steps are, because obviously there's a lot going on. You are even saying that you're explaining to him and he's not understanding. So I can't just do what you want because
No,
I
don't
did
want
what
you to do-
I did what you wanted the last time and it's not working.
And I did. I took
All
different
right,
treatment.
okay, ma'am,
took it.
I am done with this hearing at this time, okay?
And, Your Honor, I think we still have to address the violation, the new offense.
Oh. All right, and then as to the violation.
Deputies, he thought we were done, so he was leaving the room.
Deputy, can you bring Mr. Mathis back, please?
Yes, ma'am.
Okay,
And for the record, Your Honor, the state withdraws its motion,
okay,
and I'll prepare an order for the court.
thank you. All right, just to finish making the record clear, on case number 196174, CFNA, at this time, the court is revoking Mr. Mathis's bond on that case. And then as to the new arrest, there's a violation of risk protection order. The court finds probable cause. And at this time, I will impose a $2,500 bond. And I'll say,
Your Honor,
yes.
the state would also request pretrial release, GPS level 1,
Okay.
and obviously condition of no possession of firearms.
All right, level 1, pretrial, and no possession of firearms or weapons, and that includes not trying to purchase any weapons or firearms. Okay? All right, thank you, Deputy. We're done with Mr. Mathis. George Kiera. Kiera George. All right, Ms. George is before the court for a traffic KPS.
Yes, Judge, good morning.
morning.
Speaking with Ms. George, she indicated to me she's confused why she's here because she indicated on May 14th of this year, the warrant was lifted by the court.
Okay. Can someone check?
I'm checking that right now.
Thank you.
Legal assistance for the record. Do you own any properties? Circle the village of Liberty, personally.
There's nothing in the Odyssey to indicate that the KPS was withdrawn in this matter.
Does it show that she was in court? Did she have a court date on April? What date did she say?
May 14th.
Does it show that she had a court on May 14th?
No, Judge. Let me just check to see. One moment.
She indicated she has all her documents in custody with her.
Because I can't.
Your Honor,
Yes.
she's confusing this case with another case. I believe Ms. George is referring to case number 19-13018 TC48 before Judge Davis in South Satellite, where I see she was arraigned on May 14th and the KPS was withdrawn. I know.
So this case number is 19-014079 TC30A. So this is a different case number. Okay?
Judge, does it indicate when she missed court on this case? Do we have a date?
April 30th, this KPS was issued.
That's the same court date that I had rescheduled for the 15th, the 14th of May. That's the same
All
court
right.
date.
She's
and I
saying
have it in
it's-
black and
All
white.
right, I based on the information I've received, there's a different case that she was in court for. If Ms. George wants to resolve this, obviously that issue cannot be resolved here based on what the information that I've been provided. So what does Ms. George wish to do today?
Judge, can we execute the KPS and have her released once it's executed and giving her a new court date to appear on this new case?
I don't understand what you're saying.
I believe counsel's asking the court to vacate the KPS, Your Honor. She had a KPS withdrawn by another judge, but apparently she failed to appear. She's got another open case, because if you look at the short arrest warrant, Your Honor, Judge Pohl advised BSO that she had the active warrant, because she has an open case in front of Judge Pohl right now.
All right, I'm gonna leave the bond in place. I'm leaving the bond in place at this time, okay? Erica Love Smith. All right, Ms. Ms. Lovesmith is before the court for municipal ordinance violation. It's on solicitation. It's, the court finds probable cause. What does Ms. Lovesmith wish to do?
Judge, I know this is an MO case. She would like to resolve it if possible.
All right, thank you. Mr. Plant is here. Mr. Plant, is there an offer from the city?
Time served, Your Honor.
Ms. Lovesmith, what do you wish to do today, ma'am? If someone could
Would you
turn
like to
her-
resolve your
No,
case today,
her
ma'am?
mic is off. If somebody could turn her mic on, please. All right, ma'am, we weren't able to hear you before. What were you saying?
I would like to resolve in court today, please.
All right, the offer is adjudication and time served. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Lovesmith, do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
And ma'am, do you need any more time to speak with the attorney?
Yes, Your Honor.
Do you need any more time to speak with the attorney?
No, Your Honor.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
Yes, Your Honor.
Is there anything about that treatment that would prevent you from making a decision today?
No, Your Honor.
And ma'am, do you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, Ms. Lovesmith?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, ma'am, is adjudication and time served. Good luck.
Thank you.
Mr. Brown,
Your Honor, could you take a case in return at the request of North Broward?
okay?
It's on page 5, Harley Violet.
Okay.
Did you check to see if she has anything outside of Brown?
All right, Ms. Violet is before the court this morning for intimidation, writing, sending, or threatening to kill or injure. The court finds probable cause, and I'll hear from the parties, Esteban. Ma'am, hold on, I'll hear from the state.
And I would know, from what I can tell, Ms. Violet has no priors.
Okay?
That being said, I am very concerned about the allegations in this case. It does appear that Ms. Violet was targeting this particular officer, taking Snapchat videos of the officer's vehicle while at a car wash, and making threats to commit acts of violence against this officer. It appears, and I won't go into the detail, but it appears there is a motive behind these threats, Your Honor. I'm going to be requesting a $50,000 bond, pretrial release of the GPS monitor, no victim contact.
Okay.
She's never going to be able to make that kind of a bond, Your Honor. As the state points out, she has no criminal history. She's been a resident of Florida all of her life. She's been staying in the same location with a friend for the last several months. I believe that her prior contact with the criminal justice system was a drug charge. And she thinks that her mom and possibly her boyfriend can come up with some type of bond to bond her out. There are also some other issues involved with Miss Violet that has made it impossible for her to work or save up any money, so she has no money of her own to assist herself in bonding out. I'd ask the court to consider a pretrial release with a GPS. I'd ask for a mental health screening. And because otherwise, I'm not really convinced she's going to be able to post a monetary bond. Certainly not what the state is asking for.
Okay. Ms. Violet, I know you were raising your hand that you wanted to say something. I need to let you know that anything you say is being recorded and can be used against you at a later time. So
Yes, ma'am.
if you still wish to speak, with that,
Don't talk about the case, Miss Violet.
Just want to say that I'm pregnant. I wouldn't hurt anybody. I just want to raise my family. That's it.
all right. At this time, I am going to impose a $10,000 bond. That's going to also include a level 1 GPS, with an order not to possess any weapons or firearms and no contact, with the alleged victim in this case.
Yes, ma'am.
I'll make those calls for you, Miss Violet.
Thank you.
Okay, good luck.
Thank you.
Okay, Heather Stone?
North Broward also, Judge. Should like to resolve this matter if possible.
All right, Ms. Stone is before the court this morning, 1 count of petty theft, and the court finds probable cause. Does the state have an offer for Ms. Stone?
One moment, Your Honor. Offer be adjudication time served, Judge.
Okay.
Is that what you'd like to do, Miss Stone?
Yes, sir.
All right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ma'am, do you understand everything that's going on here today?
I think he said time served.
That's what
I
he
couldn't
said.
hear everything.
That's what they said, adjudication and time served.
Okay, thank you, ma'am.
Do you need any more time to speak with the attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that would prevent you from making an intelligent decision about this case?
No, ma'am.
And do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Ms. Stone?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Okay, thank you.
You're welcome. All right, Mr. Hill? If you could let me know to what, do you have persons on page 24 in the room?
The name, Judge?
Stephen Hare?
Response, Stephen Hare. Judge, VSO is going to get him now. If we can just place him on a recall?
No, that's fine. I just figured he's way down on the list and someone has signed in on his behalf.
I've been trying to reach his attorney,
Oh,
Judge.
he has an attorney, oh, he's, okay. All right, well, we haven't reached his attorney yet either, so that's okay. Who signed in on Mr. Hare?
His
Okay,
mother.
all right. So, ma'am, are you in touch with the attorney? Okay, all right, so we're waiting, no, that's okay, whenever you're ready. I just, when persons sign in, I try to see who's here and where they are, okay? And then on page 9, Jean Messidor. Who signed in on Mr. Messidor? Okay. All right. Good morning, ma'am. All right, Mr. Messidor is before the court this morning. Charge number 1 is for aggravated assault with a deadly weapon, domestic violence. Count 2 is domestic battery by strangulation, dating relationship, and charge number 2 is touch or strike battery, domestic violence. All right, the court finds probable cause.
Thank you, Judge. In speaking with Mr. Mesidor, in regards to the bonds and his financial situation, based upon the information that was provided to me, in order for Mr. Mesidor to have a reasonable chance of bonding out financially, we would ask that count 1 and count 2 be set at $2,500 bonds, and count 3, a $100 bond. In addition to those requests, I did indicate the court would be ordering a no contact with his wife, but he is asking for 2 additional things. One, that a court order be drafted that he allow access to his home for purposes of obtaining his company car and his personal car for work. He just needs those things. He's a armed security guard and he needs access to his work equipment. In addition, we'd also ask that Mr. Reedy prepare an order to allow the public defender to take pictures of the injuries provided.
Okay,
And, Your Honor, I'm going to be requesting $10,000 bond on count 1, a $10,000 bond on count 2, a $2,500 bond on count 3.
Right there now.
I would note Mr. Mesidor has no criminal history, but I am concerned about the alleged use of a firearm. According to the report, the victim was choked, felt like she was going to faint. I would note the report
Mr.
also.
Hill, if you can turn off the mic when you're not talking, because we hear everything, okay?
Thank you, Judge. I would note that the report mentions that witness statements were taken. Your Honor, I'm obviously going to request no victim contact, but as Mr. Hill mentioned, part of the no contact order I would ask it involves no possession of a firearm. There's alleged use of a firearm in this matter, and I understand he's an armed security guard, but I would ask that the court still impose that condition.
All right, ma'am, is there something you wanted to say? I'm sorry, I can't hear anything you're saying. If you can stand in front of,
No.
who are you?
I'm his wife.
Are you the
Yarnell
person?
Graham.
Are you the person mentioned in this police report?
Yes, ma'am.
Okay, and so what are you saying about the car?
The personal car that he's talking about is the car that he bought for me to get around with the kids. It's actually my car.
So there's no work vehicle?
It's a work vehicle for him. It's parked at the house.
I don't understand. Is there a separate work vehicle?
No. He said he want his work vehicle and the personal vehicle.
I know, I think
If
I
I may
heard that you
inquire, Your
wanted,
Honor?
yes.
Ma'am, the vehicle, was it provided to him by his employer?
It's one of the cars that he's talking about. It's provided to him through the company.
Okay.
And Judge, personal car is supposed to be in Jean Mesidor's name, not the wife's name. And if the court was not going to allow access for him to pick those things up in fear of the no contact order, we'd ask that the court allow Mr. Mesidor's mother then to access the equipment and vehicles he needs for work purposes.
And the only thing I would say about the work vehicle, if this is in fact a work vehicle, I would imagine it belongs to the employer,
Company,
so
right.
I don't know, and I'm not trying to put words in the court's mouth, but I don't know if the court's in a position to order who gets that car.
Right. All right. Is that the only thing you wanted to address?
It's pretty much.
Yes, Judge, other than just taking an order for pictures.
All right, I'll sign the order, but I was also speaking to, what was your name again? Yanel? All right. Is there something else you wanted to say?
No, ma'am.
All right. All right. So the allegations in this probable cause affidavit is concerning. It's alleged that a firearm was pointed at the victim's chest and that she was pushed, that she fell to the ground, and then that Mr. Mesidor then began to punch her in the chest, kicked, and so these allegations are quite concerning, and so at this time the court does find probable cause. I am going to impose a $10,000 bond on counts 1 and 2, and a $2,500 bond on count 3. I am ordering no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. And I'm also ordering no possession of weapons or firearms.
Is there a chance that that could be amended only for work purposes only? He can carry that, because otherwise we're gonna
Well,
make him,
I'm gonna leave that for a full hearing before his division judge, because at this point in time, I can't just, there has to be a hearing on that issue. So a hearing can be set before his division judge as to whether or not he can possess weapons for work. But at this time, until further order of the court, no possession of weapons or firearms. If In regards to picking up items from the home, if he wants to have his mother to the house. Now, I don't even know what that relationship is. Ma'am, is it okay for his mother to come pick up items from the home?
She don't like me
All
due
right,
to the fact because of
don't
him.
say anything more. His mother can go with law enforcement to pick up his items, only with law enforcement, okay? All right, good luck.
Judge, you can recall Mr. Stinson.
Oh. All right. All right, Solomon Stinson, what page is he on again? 26? And what location is he at?
He's in the main jail, Your Honor.
Okay. So Solomon Stinson. All right.
Your Honor, I spoke with Mr. Smith, who, as the court is aware, was here on Mr. Stinson's behalf on several occasions in the past.
Yes.
He advised me, and it is in fact true as I'm looking at it right now, that Larry Hanfield has filed a notice of appearance and a written plea of not guilty on Mr. Stinson's behalf, actually titled a temporary notice of appearance. I was advised by Mr. Smith that Mr. Hanfield is out of the country, and neither Mr. Smith nor Mr. Hanfield will be here today. I advised Mr. Smith that if he wished, they have a Arthur hearing already set up for Mr. Stinson. I forget exactly what date he told me, but it's in the near future. So I would just ask the court to set reasonable bonds on counts 5, 6, and 7. He already has, and I guess 1 and 2, but he already has a no bond hold on count 4. So, as I say, the Arthur hearing has already been scheduled, and he can resolve that in front of his judge.
Okay, thank you, Mr. Reedy.
You're welcome, Your Honor.
All right, first, Mr. Stinson, did you hear that conversation?
Yes, ma'am, I did.
All right, so there was an attorney who appeared a few times, Mr. Smith, on your behalf. And he's now told us this morning when we called that Mr. Hanfield is representing you. Mr. Hanfield did file a notice of appearance, and he already has filed some motions before your division judge, but he's out of the country and not able to appear today in court. Do you understand that, sir? All right, so I'll hear from the state.
Thank you, Your Honor. Mr. Stinson is bond eligible on counts 1, 2, 3, 6, and 7. Count 5, I don't have an objection to an ROR. I think what the BSO deputy or detective that wrote the report did was to try to cover all the bases. He couldn't charge him with attempted murder, so he charged with the murder statute and then charged with a separate count of the attempt
Okay.
statute. I'll start with count 4, which should be attempted, Your Honor, attempted murder of a law enforcement officer. I am going to be requesting that the court make a finding for first appearance purposes only of proof evident or presumption great, and that Mr. Stinson be held no bond until he can go before his judge for an Arthur hearing. I'm relying upon all the reports that have been provided to the court from, I believe, the Pembroke Pines Police Department, Broward Sheriff's Office, and I believe there's a report also from the Miramar Police Department as well, Your Honor. Should the court be inclined to order Mr. Stinson to be held no bond, I would be making bond requests in the following amounts on the other charges. Count 1 would be $100,000. 2 and 3, $50,000. Again, no objection to an ROR on 5. $5,000 on 6. On count 7, $50,000. Your Honor, I'm going to just rely upon the allegations in the report. I know Your Honor's familiar with them. These are very concerning allegations. One of the victims that Mr. Stinson shot at, the bullet only missed the victim by a matter of inches.
Okay.
As I stated earlier, Your Honor, having spoken with counsel for Mr. Stinson, they have an Arthur hearing already scheduled, so I think they're aware of and anticipating that Mr. Stinson will be held no bond at this point,
Okay.
and they can resolve that. I believe it's in front of Judge Fine whenever that hearing is scheduled.
All right. All right, so, just to clarify, because the probable cause of, determination form does not, correctly reflect that it's attempted murder on counts 1 and 4, okay? So, the court is making a finding for attempted murder on counts 1 and 4, and also finding, probable cause for the other, counts as presented. At this time, I am going to make a preliminary finding of proof evident presumption great. This is without prejudice for Mr. Stinson to have his bond hearing before his division judge based on State v. Author. And Mr. Stinson will be held no bond on count 4, okay? And then as to count 1, counts 1, 2, and 3, I am going to impose a $50,000 bond. Four is a no bond. 5, all ROR on the criminal mischief. And then on 6, I'm gonna impose a $25,000 bond. Okay, no victim contact. Yes.
Did you mean that on 7, Your Honor?
7,
Or do you have 7?
sorry, I do have 7. All right, so 7 will be a $50,000 bond.
Oh, it's still 25 on 6, Your Honor?
Yes. Okay. And Mr. Stinson is able to post his bond, no possession of no weapons or firearms. Okay? And, yes,
I was just gonna, I don't know if Your Honor was just gonna order no contact.
great.
Yeah, okay.
And Mr. Stinson, no contact with the victims in this case. Do you understand that, sir?
Yes.
And also, in case you didn't hear, your attorney has already filed a Arthur hearing, and that should be scheduled sometime before your division judge, okay?
Yes, ma'am.
All right, sir, good luck.
Thank you.
Okay. Um, Zulin Zelidon. All right, ma'am, you're before the court this morning for a felony KPS, which has a no bond hold and not for magistrate. And also there is juvenile court orders, also with no bond holds. The court finds probable cause, and you should be before your division judge on June 10th at 8:30. Good luck, ma'am. Spanish interpreter just walked in, so who needs a Spanish interpreter?
It's a municipal ordinance case in the main jail.
Okay, who's that now? Who is it? Ortiz?
Yes, Your Honor.
Eduardo Ortiz on page 11. Good morning. All right, Mr. Ortiz, you're before the court this morning for a misdemeanor KPS on a municipal ordinance violation.
Señor Ortiz, usted está acá hoy en la mañana en frente del magistrado por un delito menor, que es una orden municipal,
And the court,
orden de arresto municipal.
okay. And what does Mr. Ortiz, what do you wish to do today?
Señor Ortiz,
Judge, if the interpreter is speaking, we cannot hear her.
Okay. Mr. Ortiz, do you wish to resolve your case today?
Señor Ortiz, ¿usted quiere resolver su caso hoy?
Sí.
Yes.
All right, Mr. Plant, do you know what the offer from the city is?
Time served, Your Honor. I've met Mr. Ortiz before.
Oh, you have?
We
La
represented him
oferta,
before.
dice su abogado que la oferta es crédito por tiempo servido y que ya él habló con usted anteriormente.
Okay, Mr. Ortiz, if you wish to resolve your case today, I will sentence you to adjudication and time served.
Señor Ortiz, si quiere resolver su caso, hoy yo lo voy a sentenciar a adjudicación de la condena y crédito por tiempo servido.
Do you wish to accept that, sir?
¿Quiere aceptar eso?
Sí.
Yes.
Then please raise your right hand as best you can.
Por favor, levante la mano derecha lo mejor que pueda.
Do you swear or affirm to tell the truth?
¿Usted jura o afirma decir la verdad? No escucha la intérprete. ¿Jura o afirma decir la verdad?
Yes.
Yes.
Okay, you can put your hand down, sir.
Baje la
As far
mano.
as I know.
Baje la mano.
Mr. Ortiz, do you understand everything that's going on here today?
Señor Ortiz, ¿usted entiende todo lo que está pasando el día de hoy acá?
Sí.
Yes.
Is anyone forcing you to resolve your case?
¿Alguien lo está forzando a resolver su caso?
No.
No.
Are you under the influence of drugs or alcohol?
¿Usted está hoy bajo la influencia de alcohol o drogas?
No.
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
¿Usted entiende que tiene derecho a irse a juicio con el caso, pero al aceptar esta oferta o acuerdo negociado está renunciando a ese derecho? ¿Entiende?
Sí.
Yes.
Sí.
And have you ever been treated for mental or emotional illness?
¿Usted ha sido tratado por alguna enfermedad mental o emocional en el pasado?
No.
No.
And do you understand that if you are not a U.S. citizen,
Y entiende que si usted no es ciudadano de los Estados Unidos,
that by taking a plea today,
al aceptar esta oferta o acuerdo negociado el día de hoy,
it could subject you to deportation or immigration changes?
lo podría poner en deportación o cambios en su estatus de inmigración.
What plea do you wish to enter, sir? Guilty or no contest?
Señor, ¿cómo se quiere declarar? ¿Culpable o no contest? No voy a pelear el caso.
No conte.
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given.
Voy a aceptar su declaratoria de que no va a pelear el caso. Encuentro que ha sido dada en forma libre y voluntaria.
and I sentence you to adjudication and time served.
y lo sentencio a adjudicación de la condena y crédito por tiempo servido.
Good luck, sir.
Que tenga buena suerte.
Good morning, Your Honor.
Yes?
Paul Ryan needs an interpreter too, please.
Okay, who needs the interpreter at Paul Ryan?
Page 26, Megrento, Cruz.
All right, is this Wilmer Membrano Cruz?
Señor, su nombre es Wilmer Membrano Cruz.
Sí.
Yes.
All right, Mr. Cruz, you're before the court today.
Señor Cruz, usted está acá ante la corte hoy.
These are change of charges.
Estos son, los cargos han cambiado.
Yes, Judge.
All right, and so they're changing the charge to DUI with damage to property or person.
Están cambiando el cargo a manejar bajo la influencia con daño a una persona o propiedad.
That's number 2.
Ese es el segundo cargo.
And number 6, charge number 6 is now no valid driver's license causing serious bodily harm or death.
Y el sexto cargo es que no tenía usted licencia válida y ha causado daño serio o muerte a una persona. Daño corporal.
And has a state these charges have been filed?
Ya presentaron estos cargos al señor fiscal.
And what were the bond conditions previously? Or,
¿Cuáles eran las condiciones previas?
Your Honor, the state filed a motion for pretrial detention and first appearance.
La fiscalía presentó una moción o petición para la primera comparecencia.
Your Honor granted the motion in as far as that he would have to have a hearing in front of Judge McCarthy.
Su señoría otorgó esa moción y que usted tendría que tener una audiencia en frente de la jueza McCarthy.
Mr. Membrano Cruz had that hearing on Wednesday, June 5th, Your Honor.
A junio 5, que fue miércoles, usted ya fue a esa audiencia.
Judge McCarthy granted the state's motion and ordered him to be held no bond on all counts.
Y la jueza McCarthy el veredicto fue que usted no se le diera fianza para salir.
I tried to print a copy of the order for Your Honor, but my
He tratado de imprimir una copia del veredicto para su señoría, pero la impresora no funciona en este momento.
But I can advise, Your Honor, Odyssey reflects on June 5th.
Pero quiero que sepa su señoría que en Odyssey el programa de computadora refleja que junio 5
that the hearing was held
se llevó a cabo esa audiencia
and the motion was granted.
y se le otorgó a la fiscalía esa moción o petición.
so, Mr. Cruz,
Señor Cruz,
based on the findings of the judge you were before on June 5th,
en base al veredicto de la jueza donde usted estuvo presente junio 5,
this is just unfortunate that that hearing happened before your first appearance on the change of charge.
fue desafortunado de que usted compareciera ante la jueza antes de su primera comparecencia.
So I will adopt the findings of your division judge.
Voy a aceptar el veredicto de su jueza de división
And you will be held no bond on these 2 charges.
y se le va a retener sin fianza en estos 2 cargos ya mencionados.
Good luck, sir.
Que tenga buena suerte.
Is there anyone else who needs a Spanish interpreter?
Alguien que necesite la intérprete.
Okay, thank you.
You're welcome.
All right, then on page 12, do we have Barry Butler? Mr. Plant?
His office is also time served if he wants to accept.
All right, Mr. Butler, you're before the court for a municipal.
You have to tell me what she says.
Your Honor,
Yes?
he's very hard of hearing, so
All right, Mr.
can
Hill.
somebody,
Mr. Hill, can you help us, please?
thank you.
Yes, Judge.
All right, Mr. Butler's before the court for a municipal ordinance violation.
Here for a municipal ordinance. Am I speaking loud enough? Yeah, continue, please.
For an open container charge.
Judge, in speaking with him, if the court is willing to make an offer to resolve that matter, he'd be willing to enter a plea.
All right, the city's offer is adjudication and time served.
Judge, he will accept the court's offer, please.
All right, what plea does he wish to enter?
No contest?
Can he say that?
Say it again. No contest.
All right, so I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. All right, thank you. And then, do we have Stephen O'Neill today on page 14? He's been a medical reset for a couple of days.
Yes, Your Honor.
Anyone? Stephen O'Neill? Page 14.
Medical reset, Your Honor.
I'm sorry?
Medical reset.
Thank you very much. And
You're
then
welcome.
on page 3, Alexandra Dominique.
Is she also medical reset?
Yes, medical reset.
All right, thank you.
You're welcome.
All right. All right, Mr.
That's it for me, Judge.
I think so.
Thank
Thank you.
Judge. Have a good morning.
All right. 3. Lauren Embry. All right, Ms. Embry is before the court this morning for counts 1, 2, and 3 are grand theft. 4, 5, and 6 is uttering false bank bill, and the court finds probable cause. Does the parties wish to be heard as to bond?
Yes, Judge, thank you. In speaking with Ms. Embry, as the court can see, counts 1 through 6, we have a total of a $6,000 bond. In speaking with Ms. Embry, that's just not going to be feasible in order for her to post a monetary bond. She has resided in Florida her entire life. She does have a full-time job working for Insurance Direct, which is a telemarketing company. She's also at school at FCC, learning information about computer technology. With that said, Judge, she indicated she can afford a total of about $200. So I don't know if the court would be inclined to consider pretrial release in lieu of monetary bond.
Just to advise the court.
Yes.
And I don't
Yep,
know.
you know what, never mind, she doesn't want pretrial release, I'm sorry. But at this time, the most she can afford is $200.
Okay, does Ms. Embry have any priors?
Yes, Your Honor. And I note that this incident occurred allegedly January 8th. On February 12th of this year, she was placed on 2 years probation by Judge Duffy for dealing in stolen property and false ownership info on a pawn item.
So is she currently on probation?
She's on probation. This wouldn't be considered a violation
It was
because
that.
it occurred before she was placed on probation. But I would also note, going by the timeline, this allegedly occurred while she was out on bond on that matter.
Okay. All right, at this time, I'm gonna leave the standard bonds in place. Okay? Stephanie Britas?
No problem, Your Honor. I had to take her back. She had a physical altercation down here.
Okay, all right.
This is not Cool. If we could just put her on for tomorrow.
All right, we'll reset Ms. Britos. Thank you.
Thank you.
Ariana Saez. All right, Ms. Saez, you're before the court for a felony violation of probation, and it has a no bond hold. It's a VOP out of Palm Beach County, so she should be going up to Palm Beach soon, okay?
Thank you.
Jessica Lopez.
Medical reset.
Ms. Lopez is a medical reset. Flavio Pineros. All right, Mr. Pineros, you're before the court because you have an out-of-state felony hold, and it says no bond hold for the state of New Jersey. So you should be going before the extradition court next week, okay?
Thank you.
You're welcome. Ruben Valcourt. Mr. Valcourt is before the court on one count of aggravated battery where the offender knew or should have known that the victim is pregnant. It's domestic. The court finds probable cause. And I'll hear from the parties as to bond.
Judge, in speaking with Mr. Valcourt early this morning, he is 23 years of age. At this time, unfortunately, he's not gainfully employed, therefore creating a conflict or making it difficult to financially post a high bond. In speaking with him, if the court was inclined to set a $2,500 bond, he believes that would be reasonable in order for him to bond out.
Your Honor, the state is going to be requesting a $20,000 bond, noting the level of violence against a pregnant victim. My concern, well, one of my concerns is where this would have gone if the victim's friend was not there to stop him. Even after the friend stopped him the first time and she retreated for safety to the backyard, he followed her back there and continued to attack her, where the friend had to again stop him. I would note the physical injuries suffered by the victim. I would also note Mr. Valcourt is he's out on bond right now for possession of a firearm by convicted felon, and it was originally 2 counts. The state only filed 1 count. 1 count of possession of cannabis under 20 grams and no valid DL. He's out on,
Wait, was the possession of firearm charge filed?
yes,
Okay,
just 1 count though.
Okay.
Yes. In 2017, he was convicted of possession of firearm by convicted felon. 2017, possession of cocaine with intent to sell or distribute. 2014, grand theft auto, resisting without violence. 2014, possession of cocaine, cannabis, resisting without violence.
and when did he post bond on the charge that he's out on bond on,
January 3rd of this year.
of this year?
Yes, ma'am.
Okay. What's that case number?
That case number is 1997 CF10A.
And Judge, the only thing Mr. Valcourt wanted to make the court aware of is he indicates some of those charges mentioned by the state attorney were no info.
And that's why, Your Honor, I mentioned that only 1 charge was filed, or 1
Okay.
count.
All right, so Mr. Valcourt is out on bond on a possession of firearm under case charge, under case number 1997 CF10A. That was January of this year. At this time, the court is going to revoke his bond on that case, and he'll be held no bond. And as to this new arrest, aggravated battery on a pregnant victim, I am going to impose a $10,000 bond, no victim contact until further order of the court. That means no phone calls, no text messages, no social media, no third-party contact. And no possession of weapons or firearms. All right, Max Smith.
Judge, Mr. Smith is proceeding pro se.
All right, Mr. Smith, you're before the court for, charge number 1 is a traffic capias.
2017.
And then number 2 is domestic battery by strangulation. And the court finds probable cause, and, I'll hear from the party, the state as to bond.
Your Honor, I'm going to be requesting a $15,000 bond based on the level of violence in order of no victim contact. Mr. Smith's criminal history, 2004, dealing in stolen property and false ownership info in a pawn item. He was sentenced to 15 years state prison as a habitual offender and released in 2017. 2004 battery. One moment, Judge. .2000 battery. He has other priors, Your Honor, but the ones I've mentioned are the most recent and significant.
Okay. All right, Mr. Smith, is there anything that you wish to say in regards to setting your bond?
I don't know, madam. I'm just a well productive citizen. I pay my taxes. I got a job. I'm married, and I'm not a threat to society at all. My mistakes in the past, I accept them, and I just want to move on.
Okay. Are you planning on hiring private counsel?
I'm pretty sure this case is going to be dropped, Your Honor.
Okay. All right, so at this time, I am going to impose a $10,000 bond. If Mr. Smith is able to post his bond, he's gonna be on a level 2 GPS, no victim contact until further order of the court. Okay?
Thank you a lot, Your Honor.
Okay.
Thanks. All right.
Yes, ma'am.
I've got so much over here. Could you just hold on to that to the side too?
All right, Kimani Pierce is a medical reset,
Yes, Judge.
and Giovanni Cabreja,
Paul Ron, Your Honor.
thank you. All right, Mr. Cabreja, you're before the court for ad charges today. Number 6 is possession of cannabis 20 grams or less, and then 7 is possession of drug paraphernalia.
And Your Honor, even though they're misdemeanor charges, but they were attached to a felony case.
Okay, and so how much total bond does he already have?
Brian, do you have that? I got it.
4,100.
Sheila's got it.
Okay. All right, so, as to these 2 counts, then, the standard bonds are $100. I'll leave those $100 in place on each count, okay? All right, good luck, sir.
Thank you, ma'am.
Bobby Williams? Bobby Williams? All right, Mr. Williams, you're before the court for loitering and prowling. And the court finds probable cause.
Judge, if the state is inclined to make an offer, Mr. Williams has shown a desire to end the case here today.
One moment, Judge.
Okay.
Judge Bobby Williams. Your Honor, the state's offer at this time would be 5 days. County jail. I don't know if he's willing to accept that. And I can advise the court more information, but it's based on these allegations. He has a history of burglaries.
Okay.
Judge, he's willing to accept the state's offer.
And the only other part of the plea would be no return to this location at 341 Southeast First Street in Pompano.
Sir, did you hear that?
Yes, ma'am.
Okay, so no return to that location, and then if you'll raise your right hand, your sentence is going to be 5 days in the county jail, okay?
Yes, ma'am. Yes, ma'am.
All right, do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Mr. Williams, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Williams?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, 5 days in the Broward County Jail, credit for any time served.
Yes, ma'am. Thank you.
All right. Silvio Jean Louis.
What's this?
All right, Mr. Jean Louis, you're before the court. Charge number 1 is resisting officer without violence. Number 2 is trespassing on occupied structure or conveyance. And the court finds probable cause.
Judge, is the state in a position to make Mr. Jean Louis an offer?
Okay?
Yes, Your Honor, the offer would be adjudication, time served on both counts.
Judge, Mr. Jean Louis is willing to take the state's offer?
All right, sir, if you'll raise your right hand so that we can take a plea, do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Jean Louis, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
What you mean by that?
If you are not a U.S. citizen, taking
Oh,
a
yeah, I'm
plea.
a U.S. Yeah,
Okay.
I'm a U.S. citizen.
All right. So what plea do you wish to enter today, sir?
No contest.
All right. I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence, sir, is adjudication and time served. Good luck. Trond Johnson. All right, Mr. Johnson, you're before the court. Charge number 1 is resisting without violence. And number 2 is not for magistrate, it's a traffic infraction. The court finds probable cause.
Judge, is the state willing to make an offer as to count 1?
It would be time served, Judge.
It's time served.
Yes, Judge. Mr. Johnson would like to take the state's offer, please.
All right, Mr. Johnson, please raise your right hand. You swear or affirm to tell the truth?
No.
Okay, you can put your hand down. Mr. Johnson, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, do you need any more time to speak with your attorney?
No, ma'am.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Johnson?
No contest.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you.
All right, Bruce Hodo. All right, sir, you're before the court because you have two, it's misdemeanor capias for not showing up at your calendar call, July 26th of 2018. All right, the charges are battery and criminal mischief. You do have court on Monday before your division judge at 9 a.m.
Judge, Mr. Hodo, I don't know if the court has the ability to do so. He indicated he had court on these matters April 26th. He went to
June 12th and January
I'm
3rd.
sorry, on April 26th, he was given notice for June 12th court date. He went to court on the 12th, and then actually went back the next day on June 13th as well, because they indicated the day he was supposed to be there on the 12th, the judge was on vacation. I don't know if there's any information to support that in the file or from the state attorney.
Well, the
There's-
dates, okay.
I've got the case pulled in Odyssey. There's nothing to indicate that there was a court date for that date. What I do know is I'm showing that his July 3rd,
Let me turn off the mic, Mr. Hill, we
Thank you.
can hear better.
his
Okay,
July 3rd notice for his court appearance was mailed out May 29th. So if he was in court and spoke to a clerk on the 12th or 13th of June, I don't know why he wouldn't have been advised that he had a arraignment scheduled for July 3rd.
and the scapias was issued for July 26th
Oh.
for not appearing at a calendar call.
July 26th.
Yeah, because he indicates he was there on the 3rd.
Oh, that was 3rd.
Okay, well then, one moment.
I've been texting. I've been computer trying to pin, and every time I call to get this court date, it say pending, and I saw it's been over a year. I thought it was over with, you know.
Well,
It's pending if there's
yesterday's
a
at my house.
capias.
Well, I don't know how he was able to get the court notice because I'm showing that the court notices were returned, they weren't able to deliver them. But, I mean, at the end of the day, Your Honor, the case was transferred from Judge Hurley's division to Judge Diaz's division at arraignment. And that's going back to the middle of last year. Mr. Hodo knew this case existed. The capias was issued in July. You know, I don't know why nothing was done between almost a year.
What is, Mr. Hodo, what's your address?
My address?
Yes, sir.
51 Northeast 48th Court, Oakland Park, Florida, 33334.
And where do we, well,
581.
all right, so I have this on the capias. So on the capias, we have 581 Northeast 48th Court.
It's 51 Northeast 48th Court. You mailed it to the wrong house?
It would appear that that's probably the issue.
Oh,
Judge, if that is the case, we'd ask that the court vacate the capiases and allow Mr. Hodo to appear in court on Monday on his own accord.
And
Yes,
Your
ma'am,
Honor,
I
I
can
don't
make that.
necessarily have an objection to that as long as, if it's possible, to please keep that Monday court date, because, so the case can get moved along.
All right, so you need to be in court on Monday, June 10th at 9 a.m.
yes, ma'am, I'll be there.
I'm gonna ask the clerk to update the information to 51 Northeast 48th Court in Oakland Park.
And it's,
And, I'm
I was just
sorry.
gonna advise him what room, if Mr. Hill wants to let
Okay.
him know.
Yes,
It's
please.
room 6165, Judge Robert Diaz.
So you have court on Monday at 9 a.m. before Judge Diaz in room 6165. And so I'll ROR you on these because it appears that the capias was mailed to the wrong address. And you need to make sure you appear before your division judge, okay?
Thank you.
I'm sorry. All right, good luck, sir. Jonathan Zavaleta Diaz. He's bonded? Okay. Mike Cuevas Singletary.
North Broward.
Okay. All right, Mr. Singletary is before the court for a KPS. Looks like he missed court on May 15th of 2019, and it's a battery charge.
Yes, Judge, I know Mr. Singletary had requested of me that if we could possibly resolve it, he would like to resolve it. I advised him that sometimes battery charges are difficult to resolve at magistrate court, but since he asked me to ask, I will ask.
All right, so, Mr. Singletary, this is a battery charge, and we're not able to resolve it today, so you'll have to go before your division judge with this matter, okay?
Judge, Mr. Singletary has been living here for 16 years. He's been living the last 5 years with his family in the same location. He works for lawn service. I believe his prior criminal history consists of some misdemeanors, but no felonies. He's a graduate of high school, he graduated class of 2014. In light of that, Judge, I'd consider asking the court to place Mr. Singletary on pretrial release.
Your Honor, this, Mr. Singletary has another pending battery in addition to this one.
Okay.
No, I do not.
He has case number 193474, MM10A. That is before Judge Pohl. Your Honor, he appeared before the court April 2nd of this year. Your Honor, found probable cause and set $1,000 bond that he posted.
Okay. All right, we're gonna leave the bond in place at this time. Mr. Singletary will go before his division judge who issued the KPS, okay?
Yes.
Ronald Burgains.
So I'm not getting pretrial? Hey, Judge, now, please not get pretrial. I have to go to work. I have kids I have to take care of. I have a son.
Sir, you have to go before your division judge at this time, okay?
I'm asking, can I get off on pretrial release?
I have
Y'all
denied.
can put the ankle monitor on me.
Okay, I've denied that, so you're going before your division judge. Deputy, we're done with this hearing. Ronald Burgains.
Are you gonna be having your own meeting?
All right, Mr. Burgains, you're before the court. Charge number 1 is driving while license suspended. 2 and 3 are misdemeanor KPS. Looks like you missed court August 17th of 2018. Those charges are DUI and driving while license suspended. So the court finds probable cause, and I'll hear from the parties.
Thank you, Judge. Judge, I don't have a score sheet or his priors in front of me, but if there's a lack of history, these incidents before the court are from 2015. If there's been no trouble since then in regards to these cases, Judge, I'd ask that you take a chance and ROR Mr. Burgains and allow him to appear in court Monday on his own accord.
Well, this is a DUI enhanced.
And Your Honor, while it's a 2015 case, the KPS itself is from 2018.
Right.
And as far as any trouble since then, yeah, count 1. He was driving unlawfully again.
And how many times before this, I'm assuming he appeared for an arraignment, other status hearings?
There were previous hearings, Your Honor.
Okay, so I'm gonna deny that at this time. He'll go before his division judge on Monday. And the standard bonds, the bonds that were in place on the KPS will remain, and the standard bond on count 1 will remain. All right, Sean Wright.
Good morning, Your Honor, Paul Ryan.
Thank you.
Mr. Wright has refused to attend this morning.
Mr. Wright has refused. These are ad charges. How much bonds does Mr. Wright already have?
Your Honor, I believe, and I just spoke to Mr. Reedy, that he has no bond holds.
Okay,
If Mr. Reedy doesn't have an objection, I would just ask for a $1,000 bond on count 12.
all right, so,
I don't object.
okay, so Mr. Wright has two additional charges. Number 12 is burglary, unoccupied conveyance unarmed, and number 13 is petty theft, and the court finds probable cause and impose a $1,000 bond on count 12. Thank you, Deputy.
You're welcome.
Leroy Seymour. Sorry. All right, Mr. Seymour is before the court. This is charge number 6 on tampering in life capital felony proceeding. And the court finds probable cause.
Judge, I spoke with Mr. Brian Greenwald, who is Mr. Seymour's attorney.
Is that
Unfortunately,
Greenwald?
yeah, Brian Greenwald.
Okay,
Unfortunately, Mr. Greenwald cannot be here. Mr. Seymour does have some no bond holds.
okay.
So Mr. Greenwald has requested that I ask you to set a reasonable bond on count 8.
Your Honor.
Okay.
Tampering in this matter, it's a life felony, is a punishable by life offense. And I think it's referenced in the report, the underlying offense being a kidnapping. I believe and this has been investigated and filed, and I believe based on the evidence contained in the report, that there is proof evident or presumption great that Mr. Seymour attempted to tamper in that underlying kidnapping offense by trying to pressure and seek a waiver from the victim.
Okay. So at this time, I am going to make that preliminary finding of proof evident presumption great based on the affidavit that's been presented to the court. And as to this count, Mr. Seymour will be held no bond. Okay?
Brian.
Okay, Isaiah Altanor. All right, Mr. Altanor is before the court on additional charges, 12, 13, and 14, aggravated battery with a deadly weapon, and then 15, leaving the scene of a crash involving damage to property, and the court finds probable cause as to those counts.
Your Honor, Mr. Altanor has, let's see, 2 no bond holds locally for robbery firearm, an attempted robbery firearm hold, bond, and an out-of-county hold for armed robbery. Additionally, aggravated assault on a law enforcement officer. I'd be requesting $10,000 bonds on the 3 aggravated battery charges before the court.
Okay.
Judge, in regards to Mr. Altanor, at this time, we're just going to ask, due to the fact he's being held no bond, it's going to negate my argument for pretrial on this matter. As you can see from the docket, he is still a juvenile. Due to him being a juvenile, obviously juveniles, we can't afford any type of monetary bond. I'd ask, since he's being held no bond on firearm offenses, that we set a $1,000 bond on each one of these counts.
All right, just to make the record clear, Mr. Altanor has been direct filed, is that correct?
Yes, ma'am.
As an adult, so that's why he's before this court this morning. So at this time, the court finds probable cause, and I am going to impose $5,000 on each 12, 13, and 14, okay? Calfani Bernard.
No, Brown John, we would call by confinement status to remove him from the docket.
Right, because these are all court orders, thank you. Right. Fabian Lyon. All right, Mr. Lyon, you're before the court. Charge number 1 is felony violation of community control. 2, 3, and 4 are misdemeanor KPS. The court finds probable cause, and you do have court before your division judge on Monday, a felony judge on Monday at 8:30. Count number 1 is a no bond hold. 2, 3, and 4 have bonds attached to them, and those will remain. Okay? Mr. Lyon is trying to speak. I can't hear him.
I had missed a meeting because I was in the hospital on a Marchman Act, and that's how I missed a meeting. That's the only way that I violated. So is there any way I could go out on my own?
Well, you have a no bond hold on number 1 anyway, so that's nothing I can do about that. So you have to talk to the judge, okay? David Moore.
I'm sorry, Judge, are we waiting? Court made a finding of probable cause?
Well, I haven't said anything yet, so.
I understand. Corey, the judge, I guess, wants to know if you guys are looking to waive reading.
Yes, please. Yes, please.
All right, the
do.
court finds probable cause as
what
to
I
all
can.
4 counts, and I'll hear from the parties as to bond.
Your Honor, Mr. Moore has no criminal history. That being said, I do have a concern based on the nature of the allegations and the specific evidence contained in the probable cause affidavit. Your Honor, I'd be requesting a bond in the amount of $10,000 per count, pretrial release of the GPS monitor, no contact with minors, and no possession of any devices with internet access until further order of the court. Nothing further, Judge.
Okay?
You've heard.
Judge, I can't work here anymore. Mr. Moore has strong ties to the community. He's been here for 35 plus years. He was employed prior to being picked up for this offense. He was employed by Broward County for a long time. As you heard from the state attorney, he has no history with the system. And speaking with him in regards to his financial capability to bond out, if the court was to set a $2,500 bond as to counts 1 through 4, as well as including some type of form of pretrial release, he'd be able to post that bond.
All right, the court finds probable cause, and at this time, I am going to impose $10,000 bond on each count, 1 through 4. And should Mr. Moore post his bond, he will be on a level 2 pretrial. Also, Mr. Moore is to have no contact with any minors, and also not to possess any device with internet access. Okay?
Sorry, Judge, what was the bond that you set?
10,000 on each count.
Thank you, Judge.
Okay, Gregory Gorman. All right, Mr. Gorman, you're before the court this morning for one charge of aggravated battery causing bodily harm. And the court finds probable cause.
Your Honor, I'm going to ask that the court keep the $50,000 bond that Judge Bober set in place I believe these allegations contained in the arrest warrant affidavit are aggravating in nature. The level of violence, the injuries suffered by the victim, that Mr. Gorman left the victim unconscious in his home in a pool of his own blood. Thankfully, a neighbor went by the victim's home and saw him. And when he left the scene, he stole the victim's vehicle and was caught in Palm Beach County driving his stolen vehicle. Additionally, Mr. Gorman has a history of violence in his past. Out of Palm Beach County in 2017, burglary with assault or battery, possession of controlled substance. Oh, yeah. Possession of controlled substance. He was sentenced to a year and 6 months state prison. He was released June 1st, 2018. He's also been to state prison out of the state of Florida for child abuse. Strong arm robbery. He was sentenced to 3.5 years state prison. Go back to that one. 07, burglary of a dwelling and criminal mischief. He was sentenced to just under 2 years state prison. Additionally, Your Honor, since he's been out of state prison in Florida, I see he was arrested in the state of Tennessee, March 7th of this year for domestic assault. He's had previous arrests in the state of Nevada for domestic assault. I'm also getting hit out of New York for criminal history. Oh, and I'm sorry, Your Honor, in addition to the bond, I'd be asking for pretrial release with a GPS monitor and no victim contact.
Okay.
Judge, thank you. At this time, in speaking with Mr. Gorman in regards to this domestic dispute, in regards to his financial situation, in order for him to reasonably post a bond, could the court set bond in this matter between $2,500 and $5,000 with some form of pretrial? He understands there'll be a no contact order initiated as well, which he would abide by.
All right, based on the allegations in this affidavit to arrest, which also includes information that the alleged victim lost 4 permanent teeth. Wires were required to keep his remaining teeth in place. And also with Mr. Gorman's criminal history, the court finds probable cause and the bond is $50,000. And if Mr. Gorman is able to post a bond, he will be on a level 2 GPS and monitor, no victim contact until further order of the court. I'm glad you find it funny, sir. Ryan Webman.
No problem. Good morning, Your Honor.
All right, Mr. Webman is before the court. Count 1 is grand theft, and the court finds probable cause.
Yes, Your Honor.
Judge, we're just going to ask you to leave the bond where it is.
All right.
Yes, Ms. Powell.
All right, so you have $1,000 bond, sir.
Okay, no problem, Ms. Powell. I'd like to get this over as soon as possible. I have a 2027 release date in the federal system, so
Okay.
I'd like to just get this over with so I can move forward and get home to my girls.
All right, sir. Good
All right.
luck.
Good luck.
Thank
Good
you.
luck, Ryan.
Thank you, bud.
Brendan Forbes. All right, Mr. Forbes is before the court. Where are we having this? Where's that beep coming from?
I think it's in the walls.
All right, Mr. Forbes, you're before the court. Charge number 1 is felony violation of probation, which has a no bond hold. Charge number 2 is a felony capias. Number 3 is a felony capias. Both are no bond holds, not for magistrate. Number 4 is burglary of a dwelling or structure, armed. And then count 5 is an out of county hold on a misdemeanor charge. That's out of Dade County, and that has a $5,000 bond. And the court finds probable cause.
Judge, Mr. Forbes wanted me to indicate to the court that the probation that we're speaking about he believes is county court probation, even though it says Judge Lynch, he's aware of being on misdemeanor probation, not felony probation.
That would appear to be the case. He's on probation for battery, but I mean, it's still a no bond warrant.
Right. So, is this like a case number, was this like a down file of a felony or
The
something? On the violation of probation.
I imagine what happened, Your Honor, is that it was a felony offense that he pled out to the lesser offense of battery.
Okay.
And was sentenced to probation.
I'm just looking to see, hold on.
If you'd like to know what the original charge was, I could look that up.
Okay.
How long have you been driving? Work?
No, the warrant has the correct case number, it's a,
Who do you live
no,
with?
it still says CF10A, so.
No, it was, Your Honor, what happened was,
Works here. You ever miss court before?
okay, here's what happened, Your Honor. He had multiple felony counts in that case.
Corey, turn off your mic, please.
Sorry.
All right.
Okay, Mr. Forbes, on case number 16968 CF10A, had numerous felony charges and one count of misdemeanor battery.
Okay,
The felony charges were null prost.
okay.
At that point, when they were null prost, he pled out, and it appears it was a negotiated plea agreement. He pled out to the misdemeanor battery. So he's on probation for battery under a felony case number
Okay.
before Judge Lynch.
All right, so it is before Judge Lynch. All right, and it is a no bond hold. Okay, so, what else needs to be addressed?
Your Honor, the state on count 4, the state would be,
Four.
yes, the state would be seeking a no bond hold upon a finding of proof evident or presumption grade for first appearance purposes only, relying upon the arrest warrant affidavit by Detective Kristen Drawn of, Broward Sheriff's Office? I believe it's Broward Sheriff's Office. Oh no, I'm sorry, Pembroke Pines Police Department. Just noting that the allegations would satisfy the elements that Mr. Forbes was identified by both victims who had an opportunity to observe them in their home, and I would also note that the allegations themselves are quite aggravating.
Okay,
Yes, I've read the affidavit, and even though it may be a misdemeanor probation, Mr. Forbes still does have a no bond hold. So we're going to defer any argument regarding proof evident presumption great until such time as Mr. Forbes can appear before his division judge.
all right, finding probable cause, and as to count 4, I'm gonna make a further preliminary finding of proof evident presumption great. This is going to be without prejudice for Mr. Forbes to have a bond hearing before his division judge. And on that count, Mr. Forbes will be held no bond.
And Your Honor, just in an abundance of caution, I'd ask for no victim contact,
And
please.
no victim contact, it means no phone calls, no text messages, no social media, no third-party contact with the victims in this case. Do you understand that, sir?
Yes, Your Honor, but I don't even know who the victims are, Your Honor, to be honest with you.
And Your Honor, I would just note, I'm sure Mr. Reedy would have no issues with, or, either letting Mr. Hill know or someone from the public defender's office. I did provide Mr. Reedy with a copy of the arrest warrant affidavit.
Okay. And he does have court on Monday before his division judge as well. All right, Eugenio Delgado. All right,
Bonded.
thank you.
We're on a 10-second delay.
And then Esnel Maza.
Bonded.
5-second delay.
Sebastian White.
Approaching.
Do you have anything outside of Broward County?
All right, Mr. White is before the court this morning for possession of heroin. And the court finds probable cause.
Thank you, Judge. At this time, Mr. White is requesting an ROR. According to Mr. White, the probable cause should read that needles were found near him, not on him, and that is the entire basis for the probable cause affidavit. Sorry, the needles were on him, but that was all that was found. There was no actual narcotic, according to Mr. White, found on him.
Okay,
And I would just note, and I understand that's what Mr. White's advising Mr. Hill. There's a little bit more to it in the report. Noting, and I'm just, Your Honor, specifically referring to the allegations in the second paragraph on the second page.
yeah. The second paragraph on the page 2 of the report says, further into my investigation, as I was searching Sebastian's phone cover case, I unfolded a $1 bill, which the wind blew a white powdery substance that was inside the dollar onto my pants and arm sleeve. Sebastian immediately apologized and spontaneously uttered that it was heroin, and also said the heroin that I retrieved off the ground was his. All right.
With that said, Judge, we'd be okay with it.
Does Mr. White have a criminal history?
He does, Your Honor. 2018. Oh, no, go all the way down. Well, not this one, but yeah. Drug paraphernalia. Keep going. That was at a Delray Beach. Drug paraphernalia. Anything else? Looks like multiple counts of drug paraphernalia, and that was December of 2017 at a Delray Beach. I would not have an objection to pretrial with random testing, Your Honor.
All right. So I'll release Mr. White to pretrial supervision, and then that's going to include random drug testing. Mr. White, you need to report to pretrial office if you don't get out on time today by Monday morning. If you don't report, a warrant will be issued for your arrest, and also note that this pretrial supervision includes random drug testing, okay? All right, good luck, sir.
There was.
All right, Reginald Rouzier.
David, do you have him? Do you have him? I thought you did. My mistake. No, I know. That's not what I was saying.
You have Reginald Rouzier. All right, Mr. Rouzier, you're before the court today for 3 counts of petty theft, 2 counts of resisting officer without violence, and count number 5 is trespassing. Okay? The court finds probable cause. Does anyone wish to be heard?
Sorry, Judge, thank you. Judge, unfortunately, at this time, Mr. Rozier is homeless. And forgive my ignorance on not knowing everything about the hack program, but isn't there an order we can enter when someone's homeless to place them at the hack program, which is Broward County's #1 resource for helping homeless people? Because otherwise, if we set a bond or a pretrial, none of those 2 things are going to work. He has no money, he has no address.
How's he gonna get to the program?
Order BSO to drive them.
Well,
I don't think BSO does that.
and Your Honor, this will be Mr.
Those were
Rozier's.
the days. About, that's no more.
This will be Mr. Rozier's fourth arrest since April 26th. He was arrested April 26th on a theft. He pled that out at first appearance. He was arrested for another theft May 4th. He pled that out to time served. He was then arrested on May 13th for carrying concealed weapon and loitering or prowling. The state offered 5 days. Mr. Rozier was not interested in that. He posted a $100 bond and was released May 16th. He has priors, I believe, from other, out of New York. He has other county priors. He is, one moment, Your Honor. That's what, I direct the court's attention to, you should have a Florida career offender form from Department of Corrections in your paperwork.
Yes.
Just noting the offenses he's previously been convicted of, I would ask that the court keep the bonds in place.
Right, and I was looking through my list to see if I even have that phone number. I don't have it, so I am going to leave the bonds in place, and then he can work with his attorneys to see if something else can be arranged, okay? All right, Dwight Campbell? All right, Mr. Campbell is before the court on a grand theft charge, and the court finds probable cause. I'll hear from the parties as to bond. Does Mr. Campbell have any priors?
One moment, Judge. Technically, he has a capias from a 2012 giving a false report that was issued by Judge Levy in 2012. Other than that, is there anything?
2012?
Yeah. Other than that, no, keep going.
Okay,
That's it, Judge.
all right.
Yes, Judge, at this time, based upon his lack of history, coupled with the fact this is a property crime, not a violent crime, I'm going to ask the court take a chance, set a monetary bond at $0 and place Mr. Campbell on pretrial release with whatever conditions the court feels are just in this matter.
All right, Mr. Hill, you just have a way of saying things. I will RR Mr. Campbell and put him on pre-trial supervision, okay?
Thank you.
All right, Mr. Campbell, you need to report to pretrial supervision by Monday morning. If you don't appear, a warrant will be issued for your arrest, okay?
Thank you.
You're welcome. Michael Spinella? Thank you. John Watson?
Definitely Friday.
All right, Mr. Watson is before the court on one count of aggravated battery causing bodily harm. This is from a not in custody KPS and an incident from February of 2019. And the court finds probable cause.
Your Honor, I'm going to be requesting a $10,000 bond and no victim contact. I would note that this situation began because Mr. Watson, according to the report, was harassing a woman that had no interest, and the victim intervened out of concern for the woman, at which point Mr. Watson attacked the victim. His criminal history, he pled out a trespass and disorderly intoxication May 3rd of this year, petty theft April 5th, petty theft February 5th, resisting without violence and trespass January 23rd. He's got a theft 2017, theft 2016, robbery by sudden snatching with a battery on a public transit employee, battery and resisting without violence 2016 with a VOP, failure to leave property in criminal mischief 2014, theft and resisting a merchant 2012, battery 2011, trespass 2011, disorderly intoxication 09. Nothing further.
Okay.
Judge, at this time, unfortunately, the $10,000 bond is going to be too expensive for Mr. Watson. Mr. Watson at this time is asking if you take a chance and place him on pretrial release with level 1, which will enable him to have a monitor but work as well. He does work for an auction company in Broward County called Mannheim.
I don't think you want level 1 then.
All right, based on the allegations in this report, taking into consideration Mr. Watson's criminal history, I am going to impose a $10,000 bond, no victim contact until further order of the court. Okay, Andre Evans. Bonded. Okay, find probable cause.
Sheila.
Kenneth Cruz.
I have to double check the cash before they released it.
All right, Mr. Cruz is before the court. Charge number 1 is selling cocaine. Number 2 is possession with intent to sell New Legend drug without a prescription. Count 3 is felony violation of probation that has a no bond hold. Count 4 is possession with intent to sell, manufacture, or deliver alprazolam. Count 5 is introducing contraband into the detention facility. Count 6 is possession of 20 grams or less, possession of cannabis 20 grams or less. 7 is a felony violation of probation. That also has a no bond hold. Mr. Cruz does have court for a felony VOP on Monday at 8:30. And the court finds probable cause.
And, Your Honor, I'm just going to request that the court keep the bonds that Judge Williams set in place and the special release conditions.
All right, I know that, based on what we have before the court today, he has no bond holds on violation of probations. Those are also on drug charges.
Judge, the defense is a little confused. I asked him if he had been direct filed. Judge Williams, I'm assuming we're referring to Judge Elijah Williams, which is juvenile court.
Judge Williams was the duty judge this week. He signed an arrest warrant.
No, okay, thank you.
Right.
So his judge, the docket says Judge Williams, that is not actually his judge then?
No,
he's just the judge who signed the warrant.
all right. Okay, so at this time, I am going to leave the bonds in place. And as stated before, he's before his division judge on Monday, okay? Troy Jernigan.
Judge, on Mr. Jernigan, he has already posted bonds on 2, 3, and 4.
Yes.
All right. Troy Jernigan, please. And this is not, it's not, was he magistrated on 2, 3, and 4?
No.
Okay, okay. All right, so Mr. Jernigan is before the court on a charge number 1, possession of weapon or ammo by a convicted felon. Number 2 is possession with intent to sell, manufacture, or deliver a PVP within 1,000 feet of a school or park. 3 is possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a school or park. And 4 is possession of Ritalin. And the court finds probable cause. And just, Mr. Hill, just so you know, I've been advised by confinement that on charges number 2, 3, and 4, the bonds have already been posted. $11,000 bond has already been posted on 2, 3, and 4. The state
Thank you, Judge.
Your Honor, on count 1, I'd be requesting a $2,500 bond for the ammunition.
Okay.
Judge, I'm going to ask that since we've already set a bond on counts 2 through 4, and he's already posted that, I'm going to ask that you ROR him on count 1.
Well, count 1 is also a second-degree felony charge. So I am going to impose $1,000 bond on that, okay?
Thank you.
All right. Eddie Andrews? All right, Mr. Andrews is before the court. Charge number 1 is trafficking in MDMA. Charge number 2 is possession of cannabis 20 grams or less. And number 3 is resisting officer without violence.
What's that meant to you?
All right, the court finds probable cause. And I'll hear from the parties.
Your Honor, I'm going to request that, Your Honor, I believe the standard bond for trafficking MDMA is $50,000.
Yes.
I'm going to ask that be set on this charge. First, Mr. Andrews is out right now on bond for a pending DUI. 2012, he was convicted and violated probation for failure to register as a career offender, sentenced to just over 3 years in state prison. I'm showing, I got it. I'm just going to DOC. He was released from state prison in 2017. I'm showing prior convictions for attempted robbery with a firearm or deadly weapon. Actually, 4 separate counts out of Palm Beach County with the 5 years prison sentence. Possession of cocaine. Twelve total felony convictions in his past.
Okay.
They made a mistake. Thank you, Judge. And speaking with Mr. Andrews, he's disputing the state attorney's prior of a firearm. He said that case ultimately was without a weapon, and he went to prison on that charge, but he had no case with a firearm.
I went to prison for attempt to rob without a weapon on 4 counts, Your Honor. They sentenced me to 20 years, 5, 5, 5, and 5, running wild. When I went back to court to give back my time, they had the judge mad that I found whatever to give back, so he ran the case. Count 1, count 2 consecutive, concurrent with count 3 and count 4, so they gave me 10 years. But I never caught a violent charge in my life. It's attempt to rob without a weapon. That is not a violent charge. I'm supposed to be right now trying to get a lawyer to straighten that because they got me down like I done been convicted for 6 counts of armed robbery. I was charged with 6 counts, but I was convicted for 4 counts of attempt to rob back in 2000. I got out in 2009.
And Your Honor, just for the record, and I'm sure Mr. Hill would advise Mr. Andrews, that in the state of Florida, any type of robbery, whether completed or attempted, is considered a violent offense.
Judge, one of the things in regards to the police report, your docket says MDMA. The police report indicates that the drugs tested positive for PVP, which is Flocka. Off the top of my head, I'm not sure how much Flocka needs in regards to weight, to be trafficking, but on your docket, it's 10 grams or less, but that's for MDMA, not Flocka.
And Your Honor,
So I don't know.
this trafficking statutes cover a compound if there is a mixture of two substances, that the total weight can be considered for trafficking purposes.
But Your Honor, was never in my possession. There's 7 people in the house. They busted in the house, everybody ran.
All right,
They just
Mr. Andrews, stop talking about your case and you'll work this out with your attorney. But at this time, I'm going to impose a $50,000 bond on count 1. And, okay? All right, good luck, sir.
Judge, would the court consider 25,000?
No, sir, not for the amount of drugs that was in that house. Bradley Shield,
Bond?
SCHILD.
He's there, all right.
All right, sir, you're before the court. Count 1 is possession of cocaine, and count 2 is a traffic infraction, and the court finds probable cause.
Judge, in regards to Mr. Schild, unfortunately, a monetary bond will not work, nor will pretrial, because he currently rents a room from a motel on Van Buren Street in Hollywood. What Mr. Schild is asking for, he indicates his entire history is drug-related. Says he has no history of violent or sex crimes. Would court consider placing him at First Step Sober House on pretrial release?
Well, if First Step Sober House will take him,
Yes,
I'm
Your Honor.
I'm gonna order him to First Step Sober House. Doesn't there has to be some assessment by First Step and an acceptance by First Step?
Yes, Judge, we can just enter an order that he to be screened by First Step, and if accepted, then they can do a custody-to-custody transport for him. I assume he qualifies based on the charge. He's been there before as well, he indicated.
Your Honor, yes, Your Honor, may I, yeah, please.
Yeah,
please.
okay, so if he's been there before, then I wanna know what happened. Did he
All right,
complete?
Your Honor.
Judge, as you know, every doctor says relapse is a part of recovery, so the medical field is certain about that, so I would say that that's the reason why he, again, picked up a cocaine charge,
No.
because the medical profession indicates that is going to happen.
No, I understand that. I'm just asking what happened when he was at First Step.
Can I please explain, Your Honor?
Okay.
All right, it was about approximately 3 or 4 years ago, and I was arrested for possessing cocaine. Anyway, apparently they had an assessment evaluation. They accepted me. I was there for 8 months. I was put on pre-trial with an ankle monitor, right, until the court case was settled. And I was there for 8 months. I completed all the court dates. And in my entire history, since 1980, I've been here in Broward County. I worked at an auto body shop for 40 years. Anyway, apparently, in that case, nothing happened there. I was accepted, well accepted there. I completed the court case. I was there 8 months, right? And I was placed on probation. And I completed their program. It's a 4-month program, 4-phase thing, but you stay there longer. When I was there 8 months, and I still stayed continuously. I was placed on probation, and not soon after, maybe about 4 months after, Your Honor, I got violated for drinking an open container at the store. See, I work at an auto body shop. I have no violence on my record, no sexual thing. I've never failed to appear for any court date since 1980. But the thing is, I'm working right now, Your Honor, and I have a place. I rent the place weekly. But I'm going to lose that place. I stay, like I say,
Oh, you're gonna lose that place if you go to First Step Sober House anyway.
Oh yeah, I would rather go to First Step Sober House, ma'am. Yes, yeah. I have no control on my own like that. I've been wanting to do that for the last couple of months to go to see them, but apparently too late.
All right, okay.
Your Honor, first off, Mr. Shields' claim that he's never failed to appear, that's not true. I just checked his most recent arrest, October 12th of last year, and that was for a capias on a municipal ordinance. Your Honor, the state's position at this point is if the defense intends to seek a treatment program for Mr. Shield, that matter should be brought up before his assigned judge. Frankly, I would note, I imagine that there's plenty of inmates right now that might even have hearings set before their judges to have those things approved. To grant this at this point and let Mr. Shield leapfrog those other inmates, potential inmates that have been waiting, I don't think I don't think it's fair. He has a lengthy history. I would note he's very specific in saying he doesn't have any sexual offense priors or violent priors. He has numerous burglary priors in his past. He has a lengthy history stretching from the early '80s till now. Your Honor, I think to trust him to a program at this point, a judge should have a little bit more information than just a simple request. I've been there before. I'd like to go there again.
All right. All right, at this time, I'm gonna leave Mr. Shields' bond at $1,000, and then you can work with your attorneys on finding alternatives, okay? Donald Smith? All right, Mr. Smith is before the court on aggravated battery causing bodily harm. Count 2 is touch or strike battery. Count 3 is felony violation of probation with a no bond hold. Mr. Smith does have court on Monday before his division judge.
And
The court finds probable cause.
Your Honor, the state would be requesting a $10,000 bond on count 1, a $2,500 bond on count 2. No victim contact, noting the allegations in the report before, Your Honor, and also just noting the charges that he's on probation for before Judge Port.
Judge, the defense has no objection. I do see he has court first thing Monday morning.
All right, so 10,000 on 1, 2,500 on 2, no victim contact. Do we have Mr. Abosnina today?
I don't believe so, Judge.
Okay,
But
all right, that's the last one. All right, Stephen Hare. Okay. All right, good morning, ma'am. You've been waiting all morning. Have you been able to get in touch with the attorney that we've been waiting for?
I spoke with him, Judge. He has not yet been retained on this case, although I kind of get the impression that he will be, but he's not going to be here this morning.
Okay,
He told me he couldn't be here today, but to have Mr. Reedy handle the case today. That's what he said to do.
because you haven't yet retained him, right?
No, not yet.
Okay,
Okay.
all right.
So I just wanted to speak on behalf of my son. In his senior year of high school, his father died, and he went down a rough path. He had some bad choices and some issues, and he had a DUI like 3 or 4 years ago. But in the past year, he's really turned his life around. He's back to church since July. He's been in AA since January. He'll be 5 months sober on Sunday. He's been no drugs, no alcohol. He goes to AA, I think 5 days a week, or no, 4 days a week, and he goes to church 2 days a week, and he goes to a gym 5 days a week. He's lost 55 pounds. He's really turned his life around in the past year. And there's some questions about this case which I'm not going to discuss because he needs to talk to his lawyer. But I believe that my son. I believe my son, and just to say, I never coddled my son. I just like, oh, if he said it, it must be true. No, he'll tell you I was hard. He didn't like, so. But what he said, I believe what he said, and I've seen the evidence that he's turned his life around in the past year, 180 degrees. It's unbelievable. So just wanted to
Okay.
share that.
All right, thanks, ma'am.
Your Honor, the state is going to be seeking a $5,000 bond, noting the allegations that he, and this is according to a witness, struck a 86-year-old pedestrian. Victim was bleeding from the back of his head, had to be transported to Broward General as a level 2 trauma patient. I would also note Mr. Hare gave a version of events that is simply not corroborated by this independent witness that, from what I can tell, has no connection to either party and no motive to lie or embellish. Your Honor, I'm also going to be requesting an order that Mr. Hare not drive until further order of the court. And as his mother mentioned, he did have a DUI in 2015.
Okay,
Judge, the defense would object to the court entering any type of order revoking or suspending his driving privileges. I don't believe the court has the authority at this point to do so. In addition, I don't know if Mom or if Mr. Reedy has spoken to Mom. I don't know if that $5,000 bond is reasonable for Mom to post. for her son. I don't know if that question can be asked of the mother.
They can do it through a
I'm widow,
bondsman.
and I,
Okay. So we'll leave the bond at whatever the state requested is fine, Judge. We just object to the driver's license.
I have a job and I need to be able to get to work.
Your Honor, there are other modes of transportation, and I do believe the court, since this is a driving-related matter before the court, that the court absolutely has authority to order any relevant release conditions, which I believe an order not permitting him to drive until further order of the court would be relevant.
of course, he works in Weston and we live in Sunrise.
He also attends AA meetings that he would need to get to, so without a car, we're also then preventing him from treatment as well. If the court was to make a finding to do that to his license, the defense would, it kind of makes it seem that then we're making a decision on the merits of the case as well if we're going to suspend his license based upon this police report. So for that reason, I'm going to ask that the court stay away from that issue.
I don't understand why your argument is being presented in that manner. If you've got a reason why, and it's a legal reason why, then make a legal argument. And
You're
not,
innocent until proven guilty, so we would be assuming he's guilty on this charge.
Right.
If you're saying, so you're assuming he's guilty.
And when
So-
we get traffic cam, we'll give probably more information.
All right, okay, stop talking, everyone. Each side gets to make whatever argument they want to make. I listen and I make a decision. So to already accuse me of making a decision before I've made a decision does not make any sense. I'm assuming that he's in it. Yes, you already told me that I'm finding him guilty. I don't understand that. I don't understand that. Make your argument, make your
I have no
argument.
other argument, Judge. I'm fine. I'm done.
Right, make your argument. You don't even know if I'm gonna rule in your favor, and you're accusing me of something. I don't understand it.
I was not accusing
Yes,
the
you,
court
Mr.
of anything.
Mr. Hill, you just said that I'm finding him guilty, and I don't understand, what do you mean?
If the court was to agree with the state attorney's argument to suspend his license based upon this police report, then the court is making a finding that this police report is accurate and true, therefore violating his right to innocent till proven guilty.
Your Honor, and I'm really not trying to turn this into a back and forth, but one, the court, and no one has asked the court to suspend anyone's license. Two, under that rationale, the court could not order someone on a DUI case that they may not have alcohol or intoxicants, which the courts have been clear, the court can order that. And Your Honor, and I apologize because I know you heard from both sides, and I believe the court's ready to rule, so I have nothing further.
You make your argument, and you don't tell the judge that this is what you're doing. That's not proper court decorum. Right? You make your argument and you leave it for the judge to make a decision. Again, you don't even know how I'm going to decide. And here you are accusing me of something, but I am not vindictive, or I'm not going to punish Mr. Hare because of the actions of his attorney. So at this time, my ruling, which was going to be my ruling from the minute everybody made their argument, was that his bond is $5,000.
Thank you, Your Honor.
And he can still drive.